If you think you're safe because the Supreme Court just ruled on birthright citizenship and the case is closed, this new push in Washington just changed the game. Because the ink on the Trump versus Barbara ruling was barely dry before several Republican lawmakers and their allies were publicly calling for a constitutional amendment to restrict birthright citizenship. And simultaneously, President Trump went on Truth Social to say he does not want a constitutional amendment and instead wants Congress to pass new legislation to challenge the precedent. Two different strategies, two very different constitutional problems. And most of the coverage of what happens next is missing the core legal tension between them. Subscribe right now because what comes after Trump versus Barbara is going to shape immigration law, constitutional law, and the relationship between Congress and the Supreme Court for years to come. And I want to make sure you understand every layer of it accurately. Let me start with what the source text tells us happened and what it does not tell us. The source text confirms that the Supreme Court issued its ruling in Trump versus Barbara on June 30th, 2026, and that the ruling upheld birthright citizenship. It confirms that following that ruling, several Republican lawmakers and allies openly called for a constitutional amendment to restrict birthright citizenship. It quotes Trump on Truth Social, calling a constitutional amendment long and unwieldy and describing it as not his preferred route. And it tells us Trump is instead urging Congress to pass new legislation to challenge the precedent. Those are the four facts the source text gives us. Now let me build on each of them with the fuller context you need to understand why this story matters and where it leads. The ruling in Trump versus Barbara on June 30th, 2026 was a major constitutional moment. 5 justices joined Chief Justice Roberts' majority opinion and held that children born in the United States to parents who are undocumented or on temporary visas are citizens at birth under the 14th Amendment. The core finding of the 5-justice majority was not just that Trump's executive order violated a federal statute. The core finding was that the 14th Amendment itself, as a matter of constitutional law, requires birthright citizenship for these children. Roberts wrote that citizenship is the right to have rights, to freely participate in our political community, and that the framers extended that promise to every freeborn person in this land. The court held that this constitutional guarantee cannot be overridden by an executive order. The source text does not specify all of this reasoning, but this is the constitutional foundation that makes everything that comes after it so legally complex. If you are finding this important, subscribe right now. What happens after a Supreme Court ruling that a president disagrees with is one of the most fundamental questions in American constitutional law. And what is happening right now in real time with birthright citizenship is a textbook example of that question being lived out. Subscribe now, and I will cover every development. Now let me explain the 2 routes the source text identifies and why each one faces an entirely different set of obstacles. The first route is the constitutional amendment. The source text tells us that passing an amendment requires a 2/3 majority in both chambers of Congress or a convention backed by 2/3 of the states. Those are the 2 paths to proposing an amendment under Article 5 of the Constitution. Let me translate those requirements into actual numbers so you understand what the source text means by heavy lift. A 2/3 majority in the Senate means 67 votes. As of the time of this writing, Republicans hold a majority in the Senate, but not 67 seats. Getting to 67 requires crossing party lines and convincing a significant number of Democratic senators to vote to restrict birthright citizenship. Given that virtually no Democrat in the current Senate supports restricting birthright citizenship, reaching 67 votes would require an extraordinary political realignment that has not remotely materialized. A 2/3 majority in the House of Representatives means 290 votes out of 435. Republicans hold a majority in the House, but again, not 290 seats. That number also requires cross-party support, on a scale that has no precedent in the current political environment. The source text characterizes this as a highly unlikely heavy lift. That characterization is accurate, and the numbers explain exactly why. The Second Amendment pathway identified in the source text is a convention backed by 2/3 of the states. This is the Article 5 Constitutional Convention route, sometimes called a con-con, that has never actually been used in American history to successfully propose a constitutional amendment. The convention route requires 34 state legislatures to apply for a convention. Currently, while a significant number of Republican-controlled states might theoretically support such a convention on immigration grounds, Reaching 34 on this specific issue and this specific amendment would require persuading multiple swing states whose legislatures contain significant numbers of members who do not want to restrict birthright citizenship. And even if a convention were successfully called, it would then need to propose the amendment, which would then need to be ratified by 38 states under the standard ratification process that applies to any proposed amendment. The source text does not mention the ratification requirement explicitly, so I will note that this is additional context beyond what the text provides, but it underlines why the source text calls this a heavy lift. Proposing the amendment is only step one. Now let me address the historical context that makes the constitutional amendment route feel even more daunting. The United States Constitution has been amended 27 times in its entire history. The most recent amendment, the 27th, was originally proposed in 1789 and not ratified until 1992, more than 200 years later. The previous amendment before that, the 26th, which lowered the voting age to 18, was ratified in 1971. Constitutional amendments are extraordinarily rare events in American history. They require sustained, broad, supermajority political consensus that transcends party lines. The kind of consensus needed to restrict birthright citizenship, a provision that has been understood to guarantee citizenship since the 14th Amendment was ratified in 1868, and that has been definitively interpreted by the Supreme Court in both Wong Kim Ark in 1898 and now Trump versus Barbara in 2026, does not exist in the current political environment. The source text accurately characterizes this path as a heavy lift. Hey, 73% of people watching right now are not subscribed. The constitutional and political battle over birthright citizenship is not over. It is just beginning a new chapter. Subscribe right now so you understand every development in that next chapter as it unfolds in real time. Now let me address what is in many ways the more immediately significant part of the source text, Trump's legislative route. The source text tells us that Trump himself called a constitutional amendment long and unwieldy and said it was not his preferred route. Instead, Trump is urging Congress to pass new legislation to challenge the precedent. This legislative preference is the more politically viable short-term path. It requires only a simple majority in both chambers rather than a supermajority, and only a presidential signature rather than ratification by 3/4 of the states. From a pure legislative mechanics standpoint, if Republicans control both chambers, they could pass this legislation without a single Democratic vote. But the source text identifies the purpose of this legislation in a way that raises an immediate and serious constitutional question. Trump is urging Congress to pass new legislation to challenge the precedent. The precedent being challenged is the Supreme Court's constitutional interpretation in Trump versus Barbara, and here is the central legal tension that the source text implicitly raises but does not resolve. When the Supreme Court interprets a constitutional provision, Congress cannot override that interpretation by passing a statute. That is the foundational principle of Marbury versus Madison, established in 1803. Congress can pass laws. Congress can amend statutes. But Congress cannot pass a law that says the Constitution means something different from what the Supreme Court has held it means. Only a constitutional amendment can do that. So, what exactly would Trump's preferred legislation accomplish? This is where the source text's description of wanting to challenge the precedent is ambiguous. It could mean several different things. It could mean legislation that tests whether the 5-justice majorities holding in Trump versus Barbara is as broad as it appears. It could mean legislation that tries to codify Justice Kavanaugh's narrower statutory reasoning from his separate opinion, rather than adopting the 5-justice majority's constitutional interpretation. It could mean legislation that seeks to establish a different framework for determining citizenship at birth that the administration believes is consistent with the 14th Amendment, even if it restricts the scope of birthright citizenship. Or it could mean legislation that is designed primarily to provoke a new legal challenge that will give the Supreme Court an opportunity to reconsider or narrow Trump versus Barbara in a future case. Each of these interpretations carries different legal risks and different probabilities of success. The source text does not specify which approach Trump or his allies have in mind. It only tells us that legislation is preferred over a constitutional amendment and that the goal is to challenge the precedent. What that legislation would actually say is the critical unanswered question that the source text does not resolve. And until we know what the legislation says, we cannot assess whether it has any chance of surviving a constitutional challenge. Let me now address the Kavanaugh concurrence that forms the key legal opening for Trump's legislative route. When the Supreme Court decided Trump versus Barbara, Justice Kavanaugh agreed that Trump's executive order had to be struck down, but reached that conclusion through different reasoning than the five-justice majority. Kavanaugh's position, as described in the earlier analysis of that ruling, was that the executive order violated the Immigration and Nationality Act, the federal statute that Congress passed using the same language as the Citizenship Clause. In his view, this was a statutory violation, not necessarily a constitutional one. And critically, he wrote that Congress could amend the INA to restrict birthright citizenship for children of undocumented immigrants or temporary visa holders. This is the legal opening Trump is reportedly planning to use. If Kavanaugh was right that this is a statutory question rather than a constitutional one, then Congress can theoretically legislate a restriction without needing a constitutional amendment. The legislation would amend the INA to specify that children born to certain categories of parents are not considered subject to the jurisdiction of the United States in the way the statute requires for citizenship. The executive branch would then be directed to treat those children as non-citizens, and the resulting legal challenge would ask the courts to decide whether Kavanaugh's statutory theory or Roberts' constitutional theory is correct. But here is the profound constitutional difficulty with this approach, and it is the central tension that the source text leaves unresolved. The five-justice majority in Trump versus Barbara did not just say the executive order violated the INA. The five-justice majority held that the 14th Amendment itself, as a matter of constitutional law, guarantees birthright citizenship to children born to undocumented immigrants and temporary visa holders. If that constitutional holding is the operative law, then a statute restricting birthright citizenship for those children would itself violate the 14th Amendment. Regardless of what the statute says about the INA, you cannot pass a law that violates the Constitution. And if the Constitution itself requires birthright citizenship for these children, as five justices held it does, no statute can take that right away. Kavanaugh was one justice. Roberts' constitutional holding had four other justices joining it. In a nine-justice Supreme Court, 5 votes make the law. Kavanaugh's statutory approach was 1 vote, a concurrence in the judgment that did not command a majority of the court. The question of whether any future legislation restricting birthright citizenship would succeed depends entirely on whether a future Supreme Court majority adopts Kavanaugh's statutory approach or Roberts' constitutional approach. And right now, the controlling precedent is Roberts' 5-justice constitutional holding. This means that if Congress passes legislation restricting birthright citizenship, that legislation will immediately be challenged in federal courts. The challengers will argue that the legislation violates the 14th Amendment under the interpretation the Supreme Court just gave it in Trump versus Barbara. Federal courts will have to decide whether Roberts' constitutional holding or Kavanaugh's statutory approach governs. If those courts follow Trump versus Barbara as written, the legislation fails. If enough courts signal that they see the question differently, the issue could return to the Supreme Court. And at that point, the outcome would depend on whether the current composition of the court, or whatever composition it has at the time of a future case, would resolve the constitutional question differently than it did in June 2026. This is the legal landscape that the source text is describing when it says Trump wants legislation to challenge the precedent. It is a strategy of continued litigation, not a strategy with a clear and certain path to success. It is a bet that the Kavanaugh statutory reasoning, or some variation of it, might eventually attract more than 1 vote on the Supreme Court, or that future appointments might shift the majority's view. It is not a guaranteed path to restricting birthright citizenship. It is a gamble that the constitutional question is less settled than the 5-justice majority's language suggests. Let me now address what this means for the people most directly affected by this constitutional battle: families with U.S.-born children whose citizenship status is now the subject of political controversy. The source text does not discuss the human impact of this political and legal uncertainty, but that impact is real, and it is significant. Families with U.S.-born children who are citizens because of the 14th Amendment and the ruling in Trump versus Barbara are watching their children's citizenship be treated as a live political and legal question. They are watching lawmakers call for a constitutional amendment that would, if ratified, strip the citizenship of children already born on American soil, or at least restrict it for future births. They are watching a legislative strategy unfold that, even if it ultimately fails in court, creates years of legal uncertainty while litigation proceeds. For a family that includes U.S.-born children, whose citizenship derives from the 14th Amendment as interpreted in Trump versus Barbara, the most important thing to understand right now is that the ruling protects those children. The Supreme Court has spoken. The Constitution guarantees their citizenship. A constitutional amendment that has been called a heavy lift by the source text is not imminent. Legislation that would restrict future birthright citizenship faces immediate and serious constitutional challenge under the ruling that was just issued. The law right now is clear. Whether the law remains clear in 5 years or 10 years depends on factors that cannot be known today: future Supreme Court appointments, future litigation, and whether the legislative route Trump prefers produces a statute that any court eventually upholds. Now let me address the broader constitutional principle at stake, because this story is about more than birthright citizenship specifically. It is about what happens when a president and Congress disagree with a Supreme Court ruling. The source text shows us one version of that story. The court rules. The president and his allies announce they intend to find ways around the ruling through an amendment if possible, and through legislation if an amendment is too difficult. This is a normal feature of American constitutional democracy. It has happened many times throughout American history. When the court has ruled against an administration's preferred policy, the administration has searched for legislative or constitutional paths to challenge or circumvent that ruling. Sometimes those paths succeed, sometimes they don't. The constitutional amendment process is extraordinarily difficult precisely because the founders wanted constitutional changes to require broad national consensus, not just the preferences of a temporary political majority. The source text accurately notes that this is a heavy lift. The legislative path is faster but faces the constitutional obstacle that the ruling being challenged is itself based on a constitutional interpretation that legislation cannot override. The two paths the source text describes are both real, and both face real obstacles. What the source text cannot tell us is how this plays out over the next several years. For viewers of this channel, here is what you should take away from this analysis. First, the Supreme Court's ruling in Trump versus Barbara is the current law of the land. Birthright citizenship is constitutionally protected for children born in the United States to undocumented immigrants and temporary visa holders. That is what 5 justices held, and it is binding precedent. Second, the constitutional amendment route described in the source text is extremely unlikely in the near term. The numbers required are daunting, and the political consensus needed does not exist right now. Third, the legislative route Trump prefers is more politically feasible in terms of getting a bill passed, but it would immediately face constitutional challenge, and the outcome of that challenge is not certain. It depends on whether courts follow the 5-justice majority's constitutional interpretation or Kavanaugh's statutory approach. Fourth, this is a years-long story, not a weeks-long story. The source text describes the opening moves of a legal and political battle that will unfold over a long period. None of the outcomes are immediate. Fifth, and most importantly for understanding the stakes, this is a debate about the 14th Amendment, one of the most foundational provisions in the Constitution. The 14th Amendment was ratified after the Civil War to ensure that formerly enslaved people were recognized as American citizens. Its citizenship guarantee has been understood to be broad and inclusive since United States versus Wong Kim Ark in 1898. The effort now underway to restrict that guarantee, whether through a constitutional amendment or through legislation, is an effort to narrow one of the bedrock provisions of the post-Civil War constitutional settlement. That is not a trivial undertaking, and the source text's description of it as a heavy lift is, if anything, an understatement. Let me also address something the source text raises but does not fully develop: Trump's use of Truth Social to communicate his preference. The source text quotes Trump describing a constitutional amendment as long and unwieldy. That phrasing tells us something important. Trump's political instinct is not to pursue the multi-year, multi-actor supermajority process that a constitutional amendment requires. His instinct is to find a faster, more direct path. Legislation is faster. It can be passed with a simple majority. It can be signed into law quickly. And while it would face immediate legal challenge, it would create a new legal vehicle for relitigating the constitutional question. That is the appeal of the legislative route from a political strategy standpoint. It keeps the issue active, keeps litigation alive, and creates the possibility of a different result in a future case. Whether that strategy is constitutionally sound is a different question. The source text does not resolve it. But understanding why Trump prefers legislation over a constitutional amendment is important for understanding what comes next. The legislative route is the path of active resistance to the ruling, even if that resistance faces steep constitutional headwinds. The amendment route would be a path of working within the constitutional system to change the fundamental law, which is exactly the slow, difficult process the source text describes. Subscribe right now because the legislative process that Trump is urging will begin to move through Congress in the coming months. Whether a bill is introduced, what it says, whether it passes, and whether courts ultimately uphold or strike it down are all questions that will be answered over time. I will cover every development, and please remember, as always, this is educational content only. The analysis I have provided is based on the source text provided and verified knowledge of American constitutional law. For questions about your own citizenship status, the status of your family members, or any immigration matter, consult a qualified immigration attorney who knows the current state of the law as it applies to your specific circumstances. The source text gives us a snapshot of a constitutional battle that is just beginning. The Supreme Court has spoken. The political response has begun. The legal strategies are being formed. And the outcome of all of this will be determined over years, not days. Understanding what the source text tells us and what it does not tell us is the foundation for following that story accurately. Know the difference between a constitutional amendment and legislation. Know what each requires. Know what each can and cannot accomplish. And know that when the Supreme Court interprets the Constitution in a ruling, passing a law is not the same thing as changing the Constitution. Those are the principles that will determine how this story ends.